no question that Neil Pinkston, the city's district attorney general, well, he's actually the county's district attorney general, probably hasn't thought about it in a long time, just as he has not thought a lot in a long time, no doubt, about the mens rea requirement in Tennessee law. The mens rea requirement, mens rea means guilty mind. That is a duty for every prosecutor to prove, to argue that the criminal whom he has brought to bar intended to violate the law. That's in Title 39-11-301, requirement of culpable mental state. He has ignored this law and he hasn't thought about it in his whole career as a prosecutor. But neither have in their careers as judges Tom Greenholz, Don Poole, and Barry Steelman thought about it in Helena County either. The power of reform in existing structures is great. It is great, and yet we think that we can't solve our local problems because we have to have an outside expert come in and take care of it. So we have to get a law passed in the legislature or have Chuck Steelman introduce something to bring about some kind of reform. Maybe there's an office somewhere, an official office, that will bring it about. We just have to know how to make a proper appeal, and it'll come about. But the law requires in these two examples, law requires in mens rea that the prosecutor, the cop, they have their fellowship of the finger, right? The finger of accusation, right? You are guilty. The fellowship of the finger has the duty to uphold and respect and revere this law, which comes out of Christianity. And so do the judges, not just in criminal court jurisdiction, but in the civil, in the city court and sessions court, which also handle criminal matters of a limited type. These are inferior courts. They have a duty too, and so does the sheriff, so does the police department, serving the mayor, Andy Burke, and his police department, David Roddy, the chief. They are obligated to obey the limits of the law. Now, there's a question as to the constitutionality of police departments per se that I'm thinking about, and it comes to mind to say that because in what I want to look at now in just the next minute or two is affirmed by the Chattanooga versus Davis decision of 2001, one that has really gotten me going on an important matter. And that is, how is it that city governments can enforce statute? They have a grant to enforce certain statutes in the traffic code, that's Title 55. But if they're civil organizations, clearly under the $50 fine rule in the Constitution, how can they prosecute criminally anything at all beyond traffic? Well, it's commonly done by these organizations called police departments. That venue for prosecuting murders and rapes and robberies and assaults and trespassings and the like, that is really clearly the domain of the sheriff's department. The sheriff's department, Jim Hammond, has that authority to do, but there is an amicable professional agreement, I think, among the heads of law enforcement to allow the status quo to continue. Chattanooga versus Davis, a case brought by Larry Summers, by the way, Kevin Davis is the defendant and the appellant, overturned that system, or so the opinion would have us believe. But actually, after the opinion, nothing really happened, fundamentally, except Walter Williams was slapped down and he was not allowed to fine people past $50. As the very colorful and very humane, in a way, very humane and charming, witty, sharp, rapier-sharp jurist in the city court, who's now, I think, going to be working as in another one of these municipal these municipal judicial bodies. He is an attorney at McCoon Law here in town, and whose show, by the way, Legal Bites, we have here on Nooga Radio. Well, the Davis decision brings up a question about standing. Standing is a question that is very prominent in that case, and it tells about how Neil Pinkston has a grievance that's 16 years old now, a grievance that he, in that office, has not bothered to settle. He's not settled the grievance, and that is, in fact, the enforcement of these other laws. Taking enforcement from him, effectively, and from the sheriff's department. Now, that I'm not sure if that's a 100% accurate way of describing the effect of Davis, but Davis is an important case, and if Davis were honored the police state would end in Hamilton County, right? If it were honored by the judicial establishment, the police establishment in the state, we would have a sharp reduction in criminality. We would have many, many, many fewer prosecutions. I'm guessing an 85 to 95% cut in criminal cases charged and filed. Because the standard for mens rea, the standard for having an intent, right, seeing an intent to violate the law on the part of the defendant is important and hard to prove. It's hard to prove intent, especially on cases where if you read the bookings report at Chattanooga.com, for example, you'll see people who are charged with cases that are not about intent at all. They're about neglect, right? Failure to do something, right? Failure to show up in court, failure to pay a fee, failure to pay a fine. And we have people who are in jail today. In fact, there is an overwhelming crisis of crowding in the jails managed by, overseen by, managed by the Sheriff's Department, whose main job is to protect the court. The court being, in common law, the only form of government that a free people need. They don't need anything else. A free people does not need a legislature if they have God, and a free people that has God does not need an executive either, right? Because the executive decisions of society, of culture, are local. They're lococentric. They're decentralized. They belong to heads of household, heads of enterprises, and the court is the only really needful government. And so we have a jail crowding crisis where 66% of the people in the jail, the dump on Walnut Street downtown, 66% have not been charged. They're innocent, and yet they're in jail. And then at Silverdale Correctional Facility, there is about 39.8% of those people there. 359 of them is the number from Matt Lee, the PIO for the Sheriff's Department. 39.8% are unconvicted. They're untried, right? They're there because they can't pay. They're too poor to pay. And we need a ministry of mercy to be formed in Chattanooga by a wealthy man, maybe like you, my listener. If you're a wealthy man of import, you've done well in hedge funds, you've done well in oil and in ETFs, and even done a little bit of speculative investing in foreign currencies. You, my listener, couldn't help organize this effort to free people from the shackles, the slavery of non-payment of the bond. They can't make their bond. They can't even pay the bondman's fee, right? That's the obstacle. That they would pay the bond themselves is beyond thinking. To pay the bondman's fee, which is 10% of the whole, they can't make that either. And so they're stuck. They are stuck. Many on low numbers. You know, for you, a man of means, these are tiny numbers. $1,000 bond fee would be a $10,000 bond, which I guess is pretty common. But people can't even afford that. So we need to find a way of getting the whole bond paid and then have that money recycled. You know, cutting out the bonding industry, right? Cutting out the bonding industry. The wealthy donor pushing back against the cartel of the judicial industrial complex here in town. Okay, Neil Pinkston, let's get to him. Well, the question is of standing, and this is a kind of a mystery, which I don't think anybody has raised. Now, and you know, if well, I'm just waiting to be arrested. Okay, I'm waiting to be arrested so I can bring up some of these questions. So not that I'm asking for it. Okay, I'm just waiting for God to ordain it to happen. Some reasonable occasion for me to be at least cited. Okay, at least cited. Probably, I would probably want to be arrested to talk to the magistrate about my issue. Right. But here's the question: where does the state, Neil Pinkston, get the standing to prosecute in a criminal case? Here's what I'm asking about: where does he get this? What is standing? Standing is standing up, right? Here's how standing works. The law in Tennessee is full of the question of standing. For example, if you have a child, who can make the decisions for that child? Well, a person standing in loco parentis may make health care decisions for a person who is an unemancipated minor. That's in Title 34. What about when you're driving along the highway and a state trooper seizes your cash, seizes your good, and steals your car from you in the state highwayman program that Gerald McCormick, Republican, I think probably favors as a good conservative policy, right? Well, any party who claims an interest in the property subject to forfeiture must first establish by a preponderance of the evidence that the party is an owner or an interest holder in the property seized before other evidence is taken. The claimant has the burden of establishing standing to assert the claim. Okay, that's TCA 39. Well, that's procedure for judicial forfeiture of property. The state steals your property, millions of dollars stolen by Tennessee government on the highway, a dangerous place to go, a dangerous place, thanks to state government, our highway. And then there's one more just example, kind of a routine example before I get to Neil Pinkston. One who is a victim of a theft of services, quote, shall have legal standing to report such violations to law enforcement and testify in supporting of corresponding criminal charges. That's TCA 39. So in other words, the ability to testify in a theft case, in a theft of services, you have to have standing, and that means you have to be the victim, right? You have to be the victim. Well, what we're looking at is this question: how does the state have standing to prosecute somebody for anything? How does the state have standing to prosecute in its own name, right? In its own name, to prosecute a person for murder or for rape. Now, the reason I ask that is because every case is styled State of Tennessee versus John Doe. Well, all right, State of Tennessee, that's the plaintiff and complainant, right? Okay, well, how does that party, who's a separate party from the victim's family, how does that party gain standing? Which is a word which is a couple hundred times in the Tennessee Code. It does it, I think, under a presumption of what's called parens patrie. Parens patrie is where the state has the authority over as a legal protector of the citizens, right? Of people who can't protect themselves. Parens patrie. A similar concept is touching your children at school, and that's called in loco parentis. The school is in the place of the parents, like in loco, which means in the location of parentis, parents. The state is in the location. The school is in the place of the location of the parents. In other words, you're not there to protect your child, so we are the school in loco parentis, are the parents. We become the parents in the time your child is our inmate, right? And the state, though, the state of Tennessee, is a fictitious entity, right? In every case that Neil files, State of Tennessee versus, he is representing and presenting a fictitious religious corporation that it does not exist. It does not exist legally, I'd like to suggest, or does it? Maybe it does exist somewhere, somehow, in a mythical place. But what about legally? Legally, standing is established in several, by three means. Three means that even a criminal matter has to have. Now, and I think I'm trying to explain why we've gotten away from having this. We come into this problem. We come into this problem. Let me do it first, and then I'll tell you the three bases of standing, right? Which are not that are clearly required in civil cases, and there's nowhere that exempts a criminal prosecution from the rule of standing, except perhaps this mythical claim of in loco parentis or parens patrie, again, that being the messianic savior state, which is, in the end, it's not a legal concept. It has no basis in law. It is a religious presupposition, a religious statement of what the real world is all about, right? It's not true. It is simply a legal fiction. But standing is a threshold jurisdictional question. It is a threshold. If a court doesn't have standing, it can't make a ruling, right? It is without jurisdiction. And without jurisdiction, criminal proceedings are a nullity. Top of page 1 today is exactly this point. Tom Greenholz, I don't have the story in front of me. Tom Greenholz is saying he can't allow the prosecution of the detective in the Ooltewah rape, pool cue handle rape case because I forgot the reason now, but he doesn't have standing to prosecute that case. Forgive me for not remembering what it is, but he doesn't have standing. Therefore, nothing that. Okay, I remember because this was in a. I'm not remembering, because I'm not going to try to recreate what I read this morning. But the court doesn't have standing, and therefore the case is dismissed against this detective. I initially thought the detective's statement on the stand was not perjury at all. It wasn't perjury at all because he was not making factual statements. He was making legal analysis. That's what his legal analysis as detective. He was not a perjured person. Okay, he was not doing perjury, in my estimation, judging by what I know about the perjury statute. He was making an analysis, not making a statement of fact. That can't be perjury. Okay, that simply can't be. But Greenholz threw out the case in criminal court in today's editions of the Time Free Press, top of page 1, right? It belongs there at the top of page 1, but standing is a threshold jurisdictional question. If you don't have standing, there's nothing you can do, right? You are impotent to act. Your proceedings are a nullity. If the trial court is without subject matter jurisdiction of the defendant's case, conviction and sentence would be void ab initio. In other words, void from the beginning. Where the court is without jurisdiction, it has no authority to do anything other than dismiss the case. And a void judgment is one which shows upon the face of the record a want of jurisdiction. Again, before you can get to any issue, there is the question of standing. So what is standing, and how can Neil Pinkston prosecute without having it, as I'm suggesting? Okay? I'm theorizing that Neil Pinkston doesn't actually have standing. I'm speculating. Okay, let's say David Tulis, your host here at 92.7 and 95.3 FM HD4. I am speculating. But here are the three elements of standing, and they have to be there. There's a review of a very fine scholar of the law, who's apprised me of this, says that the three elements are the same for a civil case and a criminal case. And in order to establish standing, a party must demonstrate three essential elements. First, the party must demonstrate that it has suffered an injury which is distinct and palpable and not conjectural. Okay, so the injury has to be real. It cannot be palpable. It must be tangible, concrete, particularized, distinct, and palpable. Hypothetical presumed injuries are not allowed. Because if you don't have a real injury, you don't have standing. You have to have a real injury. How does Neil Pinkston show that the state's been injured by a murder? You see, because our jurisprudence has rejected God's law, which is totally victims' rights oriented. The state has stood in the place of the victim's family, the survivors, and pretends that it is the victim. And so it's never really about the victims anymore, or the victim's family. It's always about the state. The state is somehow offended. But who has standing in murder? Well, the survivors have standing, right? It should be that the case is John Doe, survivors, versus, these are the victim's family, right? John Doe survivors, versus Phil Schmidlap, right? Phil Schmidlap is the gunman who killed the victim. And then it should be ex rel, state of Tennessee. Ex rel means on the relation of. In other words, the state is bringing the case, the state is paying for the attorneys. It is the relator. It is relating the grievance of whom? The main party. And that would be the family, the survivors of John Doe. John Doe, survivors, vs. Phil Schmidlap, the defendant, right? The man accused of firing the gun and killing a person. So there has to be a distinct injury, and the state doesn't have it. The state does not have any injury, unless, of course, it's counting on the loss of tax revenue from this person's job or something like that, right? The taxpayer is gone, and we are poorer for it. The second rule of standing is that the party must establish a causal connection between the injury and the conduct of which he complains. There has to be a causal connection between the action and the alleged injury. Okay, that's number two. And then the third point, it must be likely that a favorable decision will redress the injury. In other words, to make it right. And the state doesn't, I don't think the state ever thinks about that. Even in the Constitution, there's a reference to the constitutional right to restitution. When has Neil Pinkston ever thought about restitution? Well, he has such a volume of cases to file, so many indictments to bring, thanks to the police department filling the dockets, right, with these paper charges, that he never even has time to think about restitution and making it that the state oversees restitution. You, my listener, have a constitutional right to restitution in Tennessee, and the state, which has stolen your case from you, pretended to be the victim, prosecuted the case for you, not on your dime, on the taxpayer's dime, and then gets this victory and forgets completely about you, the victim. You are ignored. Your grievance is muted. Justice, I would like to suggest, justice is not done in this system in which the fictional corporation of Tennessee, with Neil Pinkston as its handler, its face, and it's only the agent, right? Neil is not the state, okay? He is simply the agent, the hireling, the representative of the state. Well, if he represents the state, who is the state? Where is the state? What is it? How does it show that it's been injured? You see, this is my question. I wonder about this. And so I want you to think that there is room for reform in Chattanooga. And who should be bringing it? Who? Or whom? Well, people like you, people who care, people who matter. There are grievous wrongs being done in our judicial system, And we need to think in a 50-year time frame about reform now. And one important doctrine is that brought out by Chattanooga versus Kevin Davis, 2001. There were important points being made in there. And the door is left wide open for you to sue and stop the use of the state authorities in the case. Not on the standing issue money, but in these other areas where corporations such as Chattanooga enforce statute and don't have legal authority with which to do it. Tough question, but let's think about this more. David Tulis, I do thank you for a moment of your time. And now, some important messages.
The Tennessee Valley's news talk leader, Nooga Radio, Digital FM 95.